Imagine yourself trapped in a lion's den with nowhere to go and surrounded by danger. You suddenly find a way to escape, unscathed, only to realize you've left your hat inside. Would you return to fetch your hat? This is the story of Bruce Lehrmann and Brittany Higgins, whose case has not only captivated the public, but also highlighted the opportunity for double standards in our legal system. From the dramatic criminal trial that was abruptly halted.
A mistrial.
Obviously, everyone's disappointed by what's happened, but it would be inappropriate and irresponsible to say anything at this stage.
To the controversial civil case that followed.
Mr. Lehrmann raped Miss Higgins.
We'll uncover hidden truths and ask the tough questions. How can one man be both guilty and not guilty? And how did the same thing happen with OJ Simpson? Stay with me while we traverse different systems and cases together, uncovering the answers to the tough questions. Let's start with the criminal case. In March 2019, Brittany Higgins, a former Liberal Party staffer, accused Bruce Lehrmann, a colleague, of raping her inside a minister's office in Parliament House. The allegations were serious, and Lehrmann was charged with 1 count of sexual intercourse without consent. The accusation sent shockwaves through Australia's political landscape, igniting a national conversation about workplace culture, consent, and justice. The criminal trial began in October 2022 with Lehrmann pleading not guilty. However, the trial took a dramatic turn when it was discovered that one of the jurors had brought in outside research materials, violating the court's strict instructions and rules. As a result, the judge had no choice but to abort the trial. The prosecution planned to pursue a retrial, but this brought up another issue: the mental health of Brittany Higgins. In December 2022, the Director of Public Prosecutions announced that the charges against Lehrmann would be dropped.
In light of the compelling independent medical opinion and balancing all factors, I've made the difficult decision that it is no longer in the public interest to pursue a prosecution at the risk of a complainant's life.
The decision was made out of concern for Higgins' mental health, emphasizing that a retrial would pose a significant risk to her well-being. Higgins had been under immense public scrutiny and stress, which took a severe toll on her mental well-being. This twist left the public in suspense and raised questions about the integrity of the entire judicial process. But for all intents and purposes, there was no finding of guilt in criminal courts, and Bruce Lehrmann is no criminal according to legal standard. This, for many, would be considered a great victory in his shoes. It would be time to hang up our hat and move on with our lives. But the legal saga didn't end there. Following the dropped criminal charges, in February of 2023, Bruce Lehrmann launched a defamation suit against Network 10 and journalist Lisa Wilkinson. Lehrmann claimed that an interview aired on The Project irreparably damaged his reputation, where Brittany Higgins detailed her allegations. Even though he wasn't named directly, Lehrmann argued that he was identifiable through context clues provided in the program. He asserted that these statements falsely portrayed him as a rapist, damaging his personal and professional reputation significantly. Understandably, someone from his perspective might see that there has been no finding of guilt. How can they say I'm a rapist if I've never been found guilty of it? Now, what exactly is defamation? Essentially, if someone says or writes something about you that isn't true or can't be substantiated and it damages your reputation, that could be defamation. It doesn't matter if the defamation was spoken, written, or even in the form of a picture or online post. The same rules apply. For a defamation claim to succeed in New South Wales, there are a few key elements that need to be proven. There has to be a communication to others. The defendant must have made a communication to other people. This could be through the internet, in person, in writing, or even through art. Basically, it has to be something that others can see or hear. Identification. The communication must relate to you or identify you. This can sometimes be tricky, especially if the communication is indirect or veiled. But if people can figure out it's about you, it can count. Defamatory content. The communication must be defamatory. This means it negatively affects your reputation, lowers your estimation in the eyes of others, or causes you to be avoided or shunned. In other words, it has to harm your good name. serious harm. The publication of the defamatory material must have caused serious harm to your reputation. This is crucial. If it didn't cause serious harm, the claim might not succeed. So it's not just about being offended, it's about real damage to how others see you. Now let's talk about the possible defenses in a defamation case. Defendants have several defenses available under both common law and under statute. The main ones include justification. If the statements made are substantially true, they are not considered defamatory. Basically, if it's found to be substantially true, it's not defamation. Absolute privilege is another. Some statements are absolutely privileged, meaning they are protected no matter what. This includes things said in court or communications to certain government bodies. Honest opinion. If the statements are an honest opinion rather than a factual assertion, and they are based on proper material and in the public interest, this can be a valid defense. So if it's clearly just your opinion and not presented as a fact, you might be safe. Qualified privilege. This defense applies when the statement was made in a situation where the person making it had a legal, social, or moral duty to do so, and the recipient had a corresponding interest in receiving it. It's about balancing the duty to speak and the public's right to hear. Fair report. This applies to fair and accurate reports of proceedings of public concern, such as parliamentary proceedings or judicial proceedings. If you're reporting fairly and accurately on something of public interest, you're generally protected. Making determinations relating to defamation is all about balancing free speech with protecting reputations. Now coming back to the Lehrmann saga. Network 10 and Lisa Wilkinson stood by their reporting, arguing that the interview was based on Brittany Higgins' first-hand account and was a matter of public interest. They emphasized the importance of giving a platform to alleged victims of sexual assault. One of their primary defenses was substantial truth. For this defense to succeed, they needed to prove that Lehrmann, on the balance of probabilities, did indeed rape Ms. Higgins. This required showing not only the act itself, but also non-consent and recklessness. In a dramatic turn, the federal court judge ruled against Lehrmann, finding that on the balance of probabilities, Lehrmann did indeed rape Brittany Higgins inside Parliament House.
By conclusion on rape, Miss Higgins raped, Mr. Lehrmann raped Miss Higgins.
This defense was crucial and ultimately led to the Network 10 and Lisa Wilkinson's success in the case. Another defense they used was statutory qualified privilege under Section 30 of the Defamation Act. This defense protects the publication of defamatory material if it is considered reasonable under the circumstances. This was not the biggest point in the case, nor did Network 10 and Lisa Wilkinson win on this point as much as they did on the substantial truth defense. The main takeaway is that this was a defense they tried to use and it was not successful. It would take a long time to explain what happened here, so it's beyond the scope of this video. However, the full judgment can be accessed in the comment section on the link. Of course, you'd still remember that this is a civil case. In this civil case, the legal standard is different. Unlike the criminal court's need to find the charges proven beyond reasonable doubt, the civil court operates on the standard of proof on the balance of probabilities. This means the judge only needs to believe that it is more probable or more likely than not that the allegations are true. Justice Lee's judgment is very comprehensive, which not only goes through Lehrmann's case in detail, but also very concisely and succinctly explains the differences between the different standards in civil cases and criminal cases. Granted, not everyone has the time or the focus to read 1,098 paragraphs of a judgment, but for those who do, the information is all available in the comment section on the link. The judge most concisely put it this way. My summary in layman's terms is, on the criminal standard, that is, beyond reasonable doubt, if there is a single explanation that is consistent with innocence after considering all of the evidence, and it is reasonably possible that's what occurred, then Lehrmann has to be acquitted. But this is not the test in civil proceedings. If, on the balance of probabilities, the judge felt actually persuaded that a rape did happen, and if he is persuaded that this was what more likely happened, he can make the finding for the purposes of determining whether Lehrmann was defamed. That last part is very important because this is not a second trial to figure out if Lehrmann was actually guilty of rape. It was a trial to see whether or not Lehrmann was defamed, and if there was validity to the substantial truth defense, which was Network 10's strongest defense to the lawsuit against them. Because the judge found that Network 10 did satisfy the defense, and on the balance of probabilities, that meant that they did not defame him, and anyone can now call him a rapist, even though he was never convicted of a criminal offense. Now let's travel across the globe to Brentwood, California, where OJ Simpson faced his own legal battles. In 1995, OJ, a former NFL star, was tried for the murders of his ex-wife, Nicole Brown Simpson, and her friend Ron Goldman. Despite a mountain of evidence, Simpson was acquitted in the criminal trial because the jury found there was reasonable doubt about his guilt. But here's where it gets interesting. Both Lehrmann and OJ didn't escape the legal system entirely. After their criminal trials, they both, either willingly or unwillingly, returned to the lion's den for civil court proceedings. In 1997, OJ was found liable for wrongful death in a civil trial, where the standard of proof is lower, just a balance of probabilities rather than beyond reasonable doubt. Similarly, Bruce Lehrmann faced a civil defamation case, where the judge ruled on the balance of probabilities that Lehrmann had raped Brittany Higgins. A $33 million civil wrongful death judgment was obtained in 1997 against Simpson. The judgment was not paid in any meaningful way for the past 27 years, and with interest, it has grown to over $100 million. While sources show that Lehrmann owes nothing to his lawyers due to working on a no-win, no-fee basis, the costs decision means he still faces a big bill to cover what Network 10 and Wilkinson have forked out. Some experts estimate the total bill of the case could be up to $5 million. Both cases were heavily influenced by media coverage, and OJ's trial was dubbed the trial of the century, with every moment broadcasted live. Lehrmann's case, while not as globally sensational, dominated Australian headlines and political theatre for the past 6 years. Public reaction was intense in both cases. Many felt that justice wasn't served in the criminal trials, but found some sense of justice in the civil verdicts. Some felt that because they were found not guilty, they should not then be punished in other areas of the system. From the glitzy courtrooms of Los Angeles to the halls of Australian Parliament, both OJ Simpson and Bruce Lehrmann cases provide a window into the complexities of our justice systems and the difficulties in predicting what will happen with different cases. You might wonder, why would we even have two standards when it comes to legal cases? Why overcomplicate things? We've now seen the outcomes of the Bruce Lehrmann and OJ Simpson criminal and civil cases. Now let's talk about the practical differences between the civil and criminal standards of proof. To understand why these standards matter, we need to take a journey back in time to a principle known as Blackstone's ratio. Blackstone's ratio comes from Sir William Blackstone's 1765 treatise, The Commentaries on the Laws of England. He famously stated, "It is better that 10 guilty persons escape than one innocent suffer." This idea isn't just an old legal nugget, it's a foundational principle that shapes our entire criminal justice system. Essentially, this principle emphasizes the importance of protecting the innocent, even if it means some guilty people go free. Now, Blackstone wasn't the first to think this way. The concept has biblical origins, with the story of Sodom and Gomorrah in Genesis, and was later discussed by Talmudic scholars. Even Voltaire, the French philosopher, echoed this sentiment, although he tweaked it slightly, saying it's better to acquit 2 guilty persons than to condemn 1 innocent. Why is this ratio so important? In criminal cases, someone's freedom and potentially their life is at stake. The consequences of a wrongful conviction are severe, so the law demands a high level of certainty, beyond reasonable doubt, before convicting someone. This rigorous standard helps minimize the risk of wrongful convictions. Now contrast this with civil cases, where the standard is on the balance of probabilities. Here, the judge or jury decides based on what's more likely true, more than 50% likely. This lower standard is used because civil cases typically involve disputes over money or damages, not someone's freedom or life. The judge in the Lehrmann civil case highlighted this difference. While the same essential wrongdoing, allegations of rape, was assessed in both criminal and civil courts, the standards of proof were vastly different. In the civil case, the judge only needed to be persuaded that it was more likely than not that Lehrmann committed the act, and illustrates how the same facts can lead to different outcomes depending on the standard of proof. Now I want you to just imagine, in many cases, it is a he said, she said scenario. Nobody else knows what happened except for those two people. You are asking either judges or a group of 12 strangers in your community to judge what actually happened.
I'm not guilty.
Who is right and who is wrong? Who is telling a truth and who is not? Or which parts of what they say are the truth and which parts of what they say are a lie. Now, to put this even into more context, to understand the historical significance, consider that it wasn't until 1964 that England abolished capital punishment. Before that, a wrongful conviction could mean death. This high-stakes scenario is why the criminal standard of proof is and has been so stringent. If you were wrongly convicted back then, you didn't just lose your freedom, you lost your life. There are many animals and beasts in the jungle that is the legal system. It is a system which, whether you like it or not, is based on giving a task to strangers to decide your fate. In the dangerous wilderness, an empty den might mean you've found shelter, but it might also be inhabited by lions. One lesson that has clearly emerged from this saga: if you escape the lion's den, you don't try to get your hat. Now, I'd love to hear your thoughts. Do you think what happened here is fair? Let us know in the comments below. If you enjoyed this analysis, please like, share, subscribe to JBP Law for more in-depth legal discussions and updates. Thanks for watching, and I'll see you next time.